Caroline, karibu.
Thank you, Commissioner.
Good afternoon, Your Honor. Charity Kisotu, karibu.
Asante.
Good afternoon, Your Honor. Omwanzo Mbati, karibu.
Thank you, Commissioner.
Good afternoon, Jokindomo.
Good afternoon, Commissioner.
Good afternoon, Your Honor.
Good afternoon.
Anton Mrima, karibu sana.
Thank you, Commissioner.
Good afternoon, Your Honor.
Good afternoon, Commissioner.
Fatuma Sichale, karibu sana.
Thank you, my lady.
Good afternoon, Mheshimiwa.
Good afternoon.
Olwande Evelyn, you are welcome.
Thank you, Commissioner.
Good afternoon, Dorcas Odur, Senior Counsel and Attorney General.
Thank you, AG.
Winfrida Mokaya, Secretary, you're welcome.
Thank you.
Thank you very much, Commissioners, for that introduction. Honorable Ochoi, if you could start by telling us your county and your ethnicity.
Thank you, CJ. I come from Nyamira County. My ethnicity is Gusii.
Very well. Make yourself comfortable. We want to start the interview, although we would like it in a form of a conversation so that you are relaxed and we can get the very best out of you. I know you have sat on that chair before, so it's not very unfamiliar.
Thank you.
Yes. If you could begin by telling us who is Honorable Benard Ochoi. We want to know you in terms of your achievements, your skills, and the experience, innovations or values, and how you're going to bring this to the position of a judge of the High Court, which you have applied for. We want to know whether you are that kind of distinguished person we are looking for. What achievements have you achieved before? Because you know the challenges we are facing in the High Court, the challenges of backlog and of efficiency. So we want to know exactly how have you distinguished yourself so that you qualify for this promotion. You have 5 minutes.
Okay. Thank you very much, CJ, for this opportunity. My name is Benard Ochoi. I am a chief magistrate, and currently I am serving at Milimani Children Court. My lady, I was admitted into the bar in the year 1997. I practiced as an advocate for 7 years before joining the judiciary in the year 2005 as a resident magistrate. I have worked in the judiciary for about 21 years, and I've risen through the ranks from RM to my current position. My lady and commissioners, I have worked in several stations, specifically 7 stations across the country, and in 4 of those stations I have been the head of station. My lady, in the year 2019, I was privileged to be appointed by the then CJ as an acting chair of the Water Tribunal, and held that position until 2024, when a substantive chair was appointed. During this period, I have also served, I've had the privilege to serve as a court, as a judge advocate in the court martial. I have done about 15 court martial matters at Langata and Kawa Barracks. My lady, I've also been privileged to be appointed by my colleagues as a representative in Kenya Magistrates and Judges Association as the regional chair. I am the current regional chair in Nairobi, a position I've held for about 4 years. And I was also the chair Mount Kenya region before I was transferred to Nairobi. My lady, I'm also the captain of a football team associated with the judiciary, known as Mahakama Legends. What do I bring? My lady, I bring diverse experience with me, noting the number of years that I've worked in the judiciary and the duties that have been allocated to me. The diverse experiences in court martial matters, in the water tribunal matters, has given me a diverse experience in terms of interpretation, wide interpretation and application of the law. I have also gained experience in administration, leadership in those stations. I have been the head of station, as I've said, for a period of about in 4 stations.
I think we can get the rest
Yes. Yes. Thank you, CJ.
Thank you, CJ. Your Honor, from your presentation, you seem to be a court that deals a lot with the children matters.
Yes.
Now, I wanted to ask, in terms of Article 53 of the Constitution, the test that is set out under 53.2, that a child's best interests are of paramount importance, reads differently from, I think, Section 9 of the Children's Act, which says the best interest. So are these two standards different, the constitutional standard and the one that is set out in statute?
Thank you, Commissioner. Indeed, Article 53.2 provides that a child's best interest will be of paramount importance.
Yes.
My take is that the parameters are the same. Of course, the Constitution is a guiding law in the country, but the Children Act mostly is used in dealing with issues with the children.
Yes.
It also provides under Section 8 that a child's best interest is paramount.
Okay.
Yeah.
Now, I don't know whether you've had occasion to read a decision of the Supreme Court in the case of Mudeo Agatha versus Rahim, which set out the parameters for a parental responsibility agreement. If perhaps you can tell us, when is it that a parental responsibility agreement can be extinguished? And number 2, who can apply for it to be vacated? And lastly, how would the court go around it in terms of either upholding or setting aside such an agreement?
Okay. Thank you, Commissioner. A parental responsibility agreement is an agreement that is entered by the parents of a child or children the agreement basically lays down the terms under which both parents agree to take care of the children, or the child for that matter. It specifies what each of the parents is supposed to do in terms of maybe custody. It provides for custody of the children. It provides for maintenance, and also access of the child. So an application can be made by any of the parties for it to be extinguished, but the court has the discretion to allow or deny the parental the extinction of this agreement, because it is considered to be an agreement that has been entered between the parties voluntarily, just like any other agreement. So for it to be set aside, there must be certain grounds. Perhaps if the applicant is alleging that the agreement was not entered into maybe voluntarily, or there was undue influence that was used before this agreement was entered to. So it would depend on the grounds that have been laid before the court.
Okay. And lastly,
yes,
in a lot of contracts, especially commercial and technical contracts, you see what we call non-disclosure provisions, whereby a contract where either of the parties agree that they will not disclose the provisions of a contract and its effect to any other person, except perhaps with concurrence between those two.
yes.
Now, would it be lawful for parties who enter into a parental responsibility agreement to also include an NDA in that agreement?
It is open. I can say what I can say, my Commissioner, is that it is open. It is open to the parties to have that non-disclosure agreement. It is open to them.
Okay. Thank you, CJ. That's all.
Thank you, Commissioner.
Thank you, Honorable CJ. Honorable Ochoi,
Yes.
no doubt
Commissioner.
you are a long-serving magistrate.
Yes.
And the
Commissioner.
question I'm going to ask you is extremely simple. The offense of causing obstruction vis-a-vis the offense of careless driving, which one out of these two is a more serious offense?
Causing obstruction and
Careless driving.
careless driving. Thank you, my lady. I would consider both to be equal.
Okay, there is a reason why I'm asking you this,
Yes.
because of the question that is going to follow.
Okay.
Maybe then instead of just talking about careless driving, but we could then say causing an accident by careless driving and obstruction. Which one would be more serious than the other?
I would then consider in that case, my lady, I would consider the offense of causing careless driving and causing an accident.
Okay.
Because once an accident has happened, then it means that there are damages.
Okay.
Yes.
I just wanted us to be on that same footing before I ask you the next question.
Thank you.
So you are undertaking a trial and this accused person is charged with causing an obstruction.
Yes.
But the evidence that is led by the prosecution witnesses indicate that it was actually not obstruction, but it was causing an accident because of careless driving. What do you do in that circumstance?
So the charge was obstruction.
Yes.
But the evidence that comes in is that of careless driving.
Yes.
Thank you, my lady, for that question. Where evidence is tendered to show the evidence that has come before court proves a lesser charge, then the court can convict. If it is the evidence is charged with a more serious charge, and the evidence that comes is of the less serious offense, then the court can only convict if the evidence that is tendered is evidence that proves the more serious offense. Sorry, my lady, let me come again. I think it is confusing me. Just allow me, please.
Yes, that's okay.
Yes. So if the evidence that is tendered before the court is evidence that tends to prove the commission of a less offense, where the charge is of a serious offense, then the accused person can be convicted.
In this case,
yes,
the reverse is the situation, because you yourself said careless driving, causing
yes.
an accident by way of careless driving is more serious than obstruction.
Yes, thank you.
And so the person is charged with obstruction.
Yes.
But the evidence has disclosed that it was actually not a case of obstruction,
yes.
but of causing an accident by way of careless driving.
Thank you, my lady. In that case, I would acquit that person.
You will acquit the person?
Yeah, if he's charged with obstruction.
Are you being fair to the complainant, as it were, by acquitting the accused person? In terms of balancing the interests?
If the charge, this is, my lady, if the charge is careless driving, I think it would not be fair for me to convict for obstruction, because I would also not be fair to the accused person to convict him for a charge that he's not charged with.
You're right.
Yes.
Thank you.
Thank you very much, my lady.
Thank you, Honorable CJ, and Mheshimiwa, once again, karibu. You've said you are the one in charge of the Children's Court currently.
Yes.
Okay, thank you. And something on children. In what instances can citizenship be presumed?
Thank you, Commissioner. Maybe just a clarification. Yeah. Citizenship for a child?
There's only one instance where citizenship can be presumed. Of course, it relates to a child.
Yes.
But you explain further now.
Citizen can be presumed where a child is born. If it is in Kenya, a child is born in Kenya, then it will be presumed that he's a Kenyan citizen.
Pardon?
If the child is born in a particular country,
yes,
there is a presumption that the child is a citizen of that country.
Is it any child? Like in Kenya, let's center in Kenya. Is it any child? Any age and all that? Any parameters which should be considered for the presumption to stand?
Yes, maybe I would say a child
Yes.
of who belongs to a foreigner who's in the country, but the child was born in this country.
Okay, it's a child who is under 8 years
Like it.
and whose nationalities are known as well as the parents are unknown. 8 years and below, parents are unknown nationality. That one is presumed to be a Kenyan.
Thank you, Commissioner. I'm guided.
Now, there's a scenario. A foreign lady gets married to a Kenyan man.
Yes.
And after some time, she lawfully acquires Kenyan citizenship. This will be by registration, of course,
Yes.
by registration. That's lawfully. She goes through all the processes and she eventually gets Kenyan citizenship by registration. Now, after some time, the marriage is dissolved in court and the lady leaves the country. She goes to another country, not her country of origin, another country, and gets remarried to another man in that other country. Now, will the lady lose the Kenyan citizenship on remarrying?
The lady will, my lord, the lady will not lose Kenyan citizenship.
Thank you.
Yes.
Wish you the best.
Thank you, Commissioner. Good afternoon, AG.
You know about Wi-Fi?
Wi-Fi.
Yes.
Yes, AG.
Is Wi-Fi a tangible or an intangible asset?
I would say it is an intangible asset.
Intangible.
Yes.
There is a term called Wi-Fi piggybacking. Have you heard about it?
I have heard about it, though I may not be able to clearly state.
What have you heard about it?
I've just heard the term.
In what context? It refers
Yes.
to
Yes.
unauthorized access to Wi-Fi.
Okay. I'm guided. Thank you.
You're a chief magistrate, isn't it?
Yes, I am.
We have legislation in Kenya that criminalizes unauthorized access to Wi-Fi. Which legislation is this?
The Communications Act. I believe it is the Communications Act, Commissioner.
Okay. It is Computer Misuse and Cybercrime Act of 2018. Have you dealt with any case involving theft of Wi-Fi?
Thank you, AG. I've not dealt with any case dealing with theft of Wi-Fi.
Okay.
Yes.
That legislation criminalizes theft of Wi-Fi.
Yes.
And even though you have not dealt with it,
Yes.
you know about criminal offenses.
Yes, ma'am.
Supposing somebody is charged before you with theft of Wi-Fi, what would you be looking for to be satisfied that the charge is properly before you?
Thank you, my lady. Noting, as you indicated, that it is an intangible asset, what I would be looking at is whether this person actually had access to this Wi-Fi.
We have brought a charge sheet
Yes.
for for purposes of taking a plea,
Yes.
like any other offense, what must the prosecutor prove before the magistrate for that charge to be admitted?
For the charge of stealing Wi-Fi to be approved, there
Let me help you. For example,
yes.
if it is something you've not heard about and somebody is charged with it, won't you have to be satisfied that there is a legislation that criminalizes that offense?
Yes, the
What
legality.
else?
The legality.
What else would you be looking for? The definition?
The definition, yes.
What else?
The definition of the offense.
What else would you be looking for?
I would also be looking at maybe the sentence, the ingredients.
What else would you be looking
the
for?
ingredients of the offense.
For somebody to be charged for an offense in Kenya, what must it satisfy under the principles of rule of law?
The prosecution must prove.
Okay, it has to be an offense that is criminalized under legislation.
Yes.
It must be defined, and the penalty must be given specifically for that offense, isn't it?
Yes, yes.
Now, under this act, for example,
Yes.
unauthorized usage of Wi-Fi means that you have accessed it maybe by using somebody else's password.
Sure.
But in this act, even when there is no password, if it is open and you use it without authority, you still commit an offense. Why do you think that is so?
I think that is so because of the nature of this property. Because the nature is that it can be assessed. It can assessed without necessarily, physically having it.
Okay, we will look at it again. You are on the right track. But finally then,
Yes.
under the same act, Section 14 talks about unauthorized access, and the penalty therein is 5 million shillings or 3 years imprisonment. However, under Section 15, if you access Wi-Fi without authority and you use it to commit an offense, the penalty is 10 million and 10 years imprisonment. Why do you think there is a difference between Section 14 and Section 15?
Thank you, AG. I would say that the difference in the sentence is because in the first one, accessing illegally, that is one offense, but there is a further offense of using it to commit another offense. So I think there are two offenses. That is why the penalty is different.
So all of us would be happy if our chief magistrates would be acquainted with the new legislation so that everything is smooth, isn't it?
Yes, I agree.
Thank you.
Thank you.
Thank you, Chair. Good afternoon, Your Honor.
Good afternoon, Commissioner.
Do you want to take some water?
Thank you.
Some
I
break.
appreciate it. Thank you. Thank you.
Okay, Your Honor, you submitted decisions in matters relating to criminal case, that's anti-terror, election petition, children matters, and a court-martial case. Looking at the 5, they reflect consistent competence in issue identification, structured legal reasoning, and logical application of statutory provisions and case law.
your analyses are coherent, evidence-based with clear linkage between facts and applicable legal principle. And the tone is professional. So I commend you for that.
Thank you, Commissioner.
Now that you've mentioned you are at the Children's Court, I'll also ask you a question with regards to the area you are currently are. Section 3(2) of the Law of Succession Act defines a child to include, in relation to a female person, any child born to her out of wedlock, and in relation to a male person, any child whom he has expressly recognized or in fact accepted as a child of his own, or from whom he has voluntarily accepted permanent responsibility. What interpretive tools should you use if appointed as a judge when reading this statutory definition of a child in light with the constitutional provisions and the provisions of the Children Act 2022? Basically, what this section of the Law of Succession defines a child born out of wedlock is that can only be a child to a male person if the man had accepted responsibility and had accepted that child as his or her, his child, sorry.
Thank you, Commissioner, for that question. I would say that according to that provision, if that child is not the biological child of the man, then he has to have taken parental responsibility. So basically the section is in relation to parental responsibility. Who takes parental responsibility in a case where the father is not the biological parent of the child, and maybe the parties are staying together.
Sorry, if I just to take you back, this is with regards to the law of succession. So it's an issue around inheritance.
Inheritance.
So a woman who has a child out of wedlock, the child is recognized as her child automatically. But if the deceased is a man and had a child out of wedlock, that child can only be recognized under the law of succession if, number one, he had accepted that child as his, or he had voluntarily assumed permanent responsibility in a succession matter. So how would you, what interpretative tools would you use when reading this provision of the Law of Succession Act, especially with regards to what the Constitution and the Children Act 2022 speaks to when it comes to matters of children born out of wedlock?
Okay, thank you, Commissioner. So in relation to succession in cases of children who are born out of wedlock, the law of succession, in succession matters, the law of succession provides that if the child is not does not belong to the man, the issue that comes in is has this child been dependent on the deceased person? So there is an issue of dependency that comes in. When we relate that to the Children Act, which provides for the best interest of the child, the law provides in that section that circumstances under which that child will be recognized for purposes of the inheritance.
So the Children Act says that a child will inherit from their parent. Inheritance rights of a child are protected.
Yes.
And the children and the law of succession, on the other hand, says unless the father, in a situation where the child is born out of wedlock, unless the father assumed permanent responsibility or expressly recognized that child. Do you find that provision of the law of succession constitutional or unconstitutional?
I would find that provision. It is not in tandem with the Constitution, because the Constitution provides that a child's best interest shall always be the overriding consideration in all matters.
Okay, thank you. The court has actually declared that provision unconstitutional. Thank you.
Yes, thank you.
Yes, let me give you a scenario. You have two Kenyan students who go for studies in the US, a man and a woman. They meet, they get married, they live together in the US, they have 3 children, but eventually they don't agree and they get divorced. After some time, the husband returns to Kenya and remarries. The ex-wife and her children come on holiday to visit, and in amicable terms, they go to the High Court and register a parental responsibility agreement on issues of custody, school fees, and they're in agreement, they have joint custody. The wife then returns to the US with the children, but then decides, because now her former husband is married, she wants to secure the custody of the children, goes to a court in the US, and the court in the US gives her full custody of the children. What is the status of the parental responsibility agreement that was signed earlier? What is the status?
Thank you, my lady. In those circumstances, I would say that once a parental responsibility agreement has been entered, that parental responsibility agreement is binding on both parties until it is set aside.
But the US court has set it aside. Is that possible?
I think the US court cannot set aside that parental responsibility agreement.
Okay.
Yes.
You're correct. And there is a Supreme Court decision to that effect.
Thank
so
you.
You will read up on it.
Thank you, ma'am.
Yeah, thank you.
Thank you, Chair. Once again, good afternoon, Mheshimiwa.
Good afternoon, Commissioner.
Now, I want to discuss with you your DISPOP report.
Yes.
I first want to confirm if you've seen a copy.
Yes, I saw the copy.
And it's accurate.
I believe it is.
The one you saw? Did you verify that it's accurate?
It is accurate.
Okay.
Yes.
I'm happy you think so, because it does show that you are doing a good job at an individual level. For the period between 1st July and December 25, 1st July 2025 and December 2025, your work output was more than the expected target. You expected to carry 17% of the output. You are doing 20, which translates to 119%. That is good. Your case clearance rate is fairly okay, in the sense that it is beyond 100%. Yes. But compared to the national average, you're not doing too well. You're at 101. Your backlog situation is not so bad. 26% of your workload is backlog. Not ideal, but also not too bad. But the area of my concern majorly is your court productivity. Yes. It shows your court productivity is 291 against 370 the national average. Essentially, that means the magistrates in that court are not carrying enough weight compared to the rest of the republic, the magistrates in the rest of the republic. I don't know what you would say about that.
Thank you, Commissioner. Maybe what I could say about case productivity, number one, is that during that period, I think one of my colleagues was away on maternity leave, may have affected a little bit. Number two, it is the nature of cases that we are dealing with at the children court. And when I say the nature of the cases, I mean that most of the cases that we are dealing with at the children court, actually most of the time we are dealing with post-judgment applications. In fact, I can say that about 70% of the matters that we are dealing at any particular time are post-judgment applications. So the children court, you will find that there are many applications that come for enforcement of custody, maybe custody compliance with custody orders. There are issues of access. So you will find a matter has so many applications after judgment. So you'll find most of the time the judicial officers are handling post-judgment applications, unlike other courts where you are just dealing with matters. Once you clear, that is the end of it. So you'll find, in fact, in our court, even the number of cases that the court may have registered maybe 3,000 matters in the cases that are filed in one year. But you will find that out of those 3,000 matters, we have other applications that are being had day in, day out. That
the enforcement applications.
More than in fact, more than even 3,000 or 5,000.
You're talking about the enforcement applications?
Yes.
Okay, so in your view, what needs to be done, or what kind of support would you need, so that at least you're able to address fresh matters? Because it seems to me from your explanation, most of your time is spent dealing with already finalized matters than dealing with fresh matters that are yet to be determined.
Yes.
So what kind of support do you think you would need, or what strategies can you think of that will help improve the situation?
Thank you, Commissioner. The strategies that we have deployed is to first ensure that there is an effective mediation going on within the station. Most of our matters nowadays, we refer them to mediation. We realize that these are family matters, and in most cases we find mediation to be the most suitable. The major problem that we normally have is that when most of the time when the matters are brought in court, it is at that time when maybe the parties have separated, so they come to court when the conflict is at its peak. So we have to try and calm them down before even sense gets into them, and understand that we are dealing with the children and we need to discuss. So most of the time they do not want to discuss. That is why they come to court. But once they come to court, we do mediation at the first instance.
Mediation,
yes, at the first instance.
Any other intervention that you are currently employing to improve this? Or any support even that you think maybe the administration could help you?
Yes, in terms of support, I had requested a letter I'd written a letter requesting for more judicial officers because at the station we were, as at that time, we were 5 judicial officers. But I'm happy we have received 2 more judicial officers since December 2025. And the Registrar Magistrates Court has also promised to send 1 more judicial officer soon. So I think I'm happy with that. I'm sure we should be able to work on that.
Okay, thank you, and I wish you well. Thank you, Mama.
Thank you, Commissioner.
Thank you, Honorable Chair, and welcome again, Mheshimiwa.
Thank you.
Now, how can the judiciary maintain its independence while still engaging constructively with the executive and the legislature on matters such as budgeting and administration of justice?
Thank you, Commissioner. The independence of the judiciary is a critical component of the judicial system. There are several mechanisms that have been set by the judiciary to ensure that we maintain our independence. And number one, in terms of institutional independence, the judiciary maintains independence by laying out structures that ensure that there is no interference from outside in terms of the decisions that are made in the judgments that are delivered in court. We have a judiciary fund. That means that the judiciary does not have to so much keep asking for funds to in order to operationalize its services. There is a better remuneration for judges, magistrates. The terms of service have also been improved. The judiciary is also accountable in terms of budget making. The judiciary makes its budget. It is taken to Parliament for approval. So it is us who do our budget, though it may not be, it may not be passed entirely the way it is proposed, but the judiciary has that opportunity to prepare its own budget. Thank you.
Okay. Thank you. I wish you all the best.
Thank you, Commissioner.
Thank you, Honorable CJ. Mheshimiwa, what is the biggest challenge you've experienced in your role as a judicial officer?
Thank you, Commissioner. I must say that my biggest challenge was basically at the time when I was joining judiciary, sitting in court, listening to matter and giving a sentence. In fact, the biggest one was meting a death sentence at that time. But over time, with the training experience, I think that's no longer a challenge. One other challenge, that one is from now my current station. So the biggest challenge is dealing with parties who have come to court conflicting over children. And then when they come to court, the pleadings indicate that they are for the benefit of the children, but most of the time, you may find that these parents actually, the reason why they are in court is, because of the dispute that they had between them, and yet they are innocent children who are involved, who are in between. So you may find them fighting each other. They don't want, for instance, to give access. Like when we deal with the cases of access, a parent does not want the other to access the child. The innocent child does not even know that there is a matter that is in court or that the parties are fighting. So that now, when we are dealing with this matter, we do not just think of the pleadings, but at the back of our mind, the children who are involved. So we try to understand whether this is a case where the interests of the child are really at stake, or whether parties are just maybe fighting, trying to get a score over the other.
Okay.
Yes.
Do you mentor those who work under you? It's a yes or no?
Yes, I do.
Okay. Maybe you can give us then an example of a successful mentoring relationship you've had and its impact.
Thank you, my lady. A successful mentoring example that I can give is that I mentored a judicial officer who had freshly been recruited and was sent to my station as the first station. So she had totally never sat in any court. She didn't know how the proceedings were being conducted. She was scared and all that. But when she came in, we sat together for a period, maybe, around 3 weeks, seeing how we conduct proceedings in court, advising her on how to proceed. I let her ask questions where she was not clear. And right now, the judicial officer was employed at that time as a resident magistrate. And right now, she is serving as a principal magistrate, working very well.
You've carried on that relationship to date?
Yes.
Okay.
Yes.
All right. Thank you, and I wish you well.
Thank you.
Good afternoon again.
Good afternoon, Vice Chair.
Yes. What is the role of the judiciary in socio-economic development?
Thank you, Commissioner. The judiciary plays a big role in social economic development in terms of the decisions in resolving disputes, because in any economic environment you'll find that there are disputes, and also there are also social disputes in any society. So the judiciary, through the decisions that we make, plays a big role in resolving those disputes, and it is the duty of the judiciary to ensure that the economic disputes, social disputes that come before court are resolved quickly, they are resolved judiciously, so that the people who come before us can be able to move on with their lives.
Okay, thank you.
Thank you, Commissioner.
Thank you very much, Mheshimiwa and commissioners. What is the case round at the Children's Court where you are?
At the moment, Okay, let me give the statistics up to December. There were 3,000. We have been 5 magistrates, but some magistrates were, as I had indicated, some magistrates were sent. 2 more magistrates.
So you are about 7?
Yes.
All right. And these cases, you say the backlog is 1,488. The backlog.
Yes, my lady.
This worries me. Are these cases seeking a determination of custody, maintenance, that kind of thing? And if it's kept waiting, won't they be overtaken by events?
Yes.
A child will even grow when the case is in the court.
Okay, thank you, CJ. These cases are mixed. We also do criminal matters.
Yes.
Involving children. And what happened last year?
And I imagine most of them is defilement.
Mostly, yes, most of the, a good number is defilement. So last year, one of the reasons why we have this number of cases is that there are many cases that have been transferred to our court from different courts within Nairobi, especially the defilement cases. So that is one of the reasons why that number increased. So all courts, for instance, we received cases from Makadara, Dagoretti, City Court. So they increased this number a bit. Some of the other cases that could be pending are cases that have been sent to court annexed mediation that have not come back to us.
Okay.
Yes.
Yeah, but I wonder whether you have a strategy to deal with these matters, because they actually are time sensitive.
Yes, my lady.
Talk about a child who is a victim of a crime.
Yes.
You don't want them to keep coming back and forth.
Yes.
To be a witness.
Yes. Maybe
if it's a child seeking maintenance or custody, you also want to deal with it expeditiously.
True.
So that they don't keep coming back and forth and outgrow even the system.
I agree, my lady.
Yes.
Yes.
So I wanted to hear your strategy.
My strategy, allow me, my lady, before.
Yeah, because if you have a backlog of this nature and then we are taking you to the High Court, we are wondering, are we helping ourselves?
Thank you, my lady. As indicated, the challenge that we have been having first is the numbers, but as I've indicated, we have now been given some more magistrates. However, we have a strategy as a station in dealing with these matters, especially the matters that have come in from other stations. Which were not in our system. For the criminal matters, one of the problems that we have been facing is that some of these children who are in conflict with the law come from these informal settlements. When they are brought before court and charged, sometimes we do not want to keep them in remand because they are not able to afford bond terms. So in many cases we release them on very reasonable, sometimes even on free bond terms. So there is one challenge that we have been facing. That is these children coming back to court for cases to proceed. But we we are working closely with the children officers and the officers to ensure that these children come to court. We have also been having a problem of getting witnesses. These children cases, one challenge actually in having them disposed quickly is the fact that most of the time these children are in school. So when they are in school, it means that during the term, we may not be able to get the children witnesses, and some of them even coming to court for cases. So sometimes we are a bit lenient so that we give them time to go to school so that we don't fix cases during the school term. So the strategy that we have made is to ensure that during the school holidays, our judicial officers, most of our judicial officers are working so that we are able to deal with these cases concerning the children.
Very well.
Yeah.
So I think this brings us to the end of this interview, but we always give a candidate an opportunity also to engage us. So this is your opportunity.
Thank you very much, my lady. Thank you for giving me this opportunity to engage. I thank you for this. I also to commend the Commission for the good work it is doing, especially this process. It is a long process, and I pray that God gives you the strength to continue until the final end. Thank you so much.
Thank you. Thank you very much. On behalf of the commissioners and on my own behalf, I wish you success. We'll get in touch with you when we complete this very, very competitive exercise. Meanwhile, we always encourage candidates to focus on always doing the right thing and serving Kenyans with distinction. You are now released. Have a nice afternoon. Someone will show you where you can have some lunch.
Thank you very much, CJ.